as well. Great, wonderful. So as I said, hello everyone and welcome to the webinar series on recent developments in copyright law in South Africa. This series is a collaboration between the Mandela Institute at WITS in Johannesburg and the program on information justice and intellectual property at the Washington College of Law at the American University in Washington. By way of introduction, I am Sanya Samtani, senior researcher at the Mandela Institute. And I'm going to tell you a little bit about the webinar series before we dive in to an introduction to the speaker, and then I will hand over to Professor Sean Flynn, who's going to be doing our first lecture. So the aim of the lecture series is just to provide clarity on a fast evolving area of law that has seen litigation and parliamentary reform, as well as a fair bit of international trade relations, policy making as well. It's also the object of public discourse. So really what this webinar series aims to do is to demystify the recent developments in copyright law for everyone to understand. Our webinar series kicks off with the first webinar titled International Copyright Trade Policy and South Africa. There are other webinars that have been planned, and the schedule for these webinars will be released shortly after this one. So that those who are interested can attend the different series. Each of the webinars will be focusing on a different area of copyright law and a different group that it might affect, and different topics that relate to it as well. We'll get into that as each webinar proceeds. I will be the moderator for all the webinars. I will speak at some of them, but for this one, I'm just the moderator. So just to introduce to you all, Professor Sean Flynn, who teaches courses on the intersection of intellectual property, trade law, and human rights. He's also the director of the program on information justice and intellectual property, PIGIP for short. Professor Flynn chairs the Global Expert Network on Copyright User Rights and is also a founding member of the Global Congress on Intellectual Property and the Public Interest. A little known fact about Professor Flynn is that he was clerk to Chief Justice Arthur Chaskalson at the South African Constitutional Court, as well as Judge Raymond Fisher at the U.S. Court of Appeals for the Ninth Circuit. So Sean has definitely been to South Africa and very much embedded in the South African scene. With that, I will hand over to Professor Flynn to begin your presentation. Just a little note on the format of our webinar, which I had forgotten to mention before. So Sean will provide an overview of the topic and will take between 30 and 35 minutes to present the lecture, after which we will open up the floor for general discussion and questions and answers. So please feel free to sort of type in the chat if you have any burning questions, and I will try to consolidate that and pose them to Sean at the end. Over to you, Sean.
Good. Thank you so much, Sanya, and to the Mandela Institute for hosting this series. And as I mentioned, PIGIP is a co-host of this series, but really Sanya is doing all the work. We're really just supporting it in spirit and helping to organize, some of the speakers, but really it's all Sanya's effort and the Mandela Institute's effort, and I really appreciate it on this important topic. I really do encourage people to use the chat, as Sanya said, to kind of let us know if there are some different kinds of questions. I'm not going to be reading the chat as I go through the lecture, so I'm going to take Sanya up on the offer to kind of monitor that, but I'll see as the chats pop up, and it'll give me a little bit of an indication of how eager people are to discuss, or if I should just kind of present a little further, because this topic, it could go on forever. But I'm gonna be careful to look at my 35 minutes or so and kind of take a little read on where we are with the discussion. So it's an interesting kind of starting place for this series, to start with the international law aspects and especially the trade law disputes. And I say it's kind of interesting because as I'll present to you, hopefully rather forcefully, there is no trade law dispute here. It's really one of those issues that has very little legal substance, but it does have a lot of political substance. And I'm actually going to start with the political economy and discuss a little bit of the history of trade threats against South Africa, particularly over its adoption of what we call the international flexibilities in the international system, the policy space that is given to countries to design their own IP according to their own economic and social policy interests. And then turn back to the legal issues and kind of show you, the black letter law and the issues. And then, but I think taken together is that this is as much or more of a political issue than a legal one in this area. But it also provides us an opportunity to kind of look at some of the main political critiques around the bill, and especially around fair use, which has become, it's very interesting to me that this kind of complaint about adopting a US style fair use exception within the limitations and exceptions in copyright has become the hottest issue in South Africa, as if that is really the most radical thing the bill does. And I'm going to conclude, if I have time, by arguing that it's not the most radical thing the bill does, that there's much more radical provisions that I also think are justified, but that aren't really getting as much attention, although perhaps are really the underlying concerns of some of the industries, etc. So let me see if I can heat up these slides. I think they should be on your screen already, and let me just see if I can control them. Okay, cool. So you may have heard, I've certainly seen it come up in the South Africa press every so often. It seems like every 6 months or so, there's some kind of article in the Sunday Times or some other, newspaper saying that the US is threatening South Africa over the adoption of, especially a fair use right is usually how it's termed, that the adoption of fair use, or the proposal to adopt fair use within the South Africa copyright bill, is drawing US and even European trade threats. And that's kind of true. There have been, we know from various Freedom of Information Act requests and etc., using freedom of information laws in the US and EU, that in fact the major content industries, largely the different kinds of distribution platforms, so the record labels, the publishing companies, have been lobbying the United States Trade Representative and the equivalent institutions within the EU to threaten South Africa with some kind of trade sanctions, usually the denial of preferential treatment under their trade laws, the removal of special and differential treatment that accords South Africa preferential tariffs under the US and EU trade regimes. That these large content industries have been lobbying the US and EU to threaten to remove those benefits because of the consideration of the adoption of a fair use right within the copyright amendment bill. And so that part is true. Those industries have been lobbying those officials, and we also know that those officials have been having various kinds of dialogues with the South Africa government that could be interpreted as possibly including threats. We don't actually know. We don't have evidence that the US and EU has literally threatened to revoke trade sanctions. We do know that in the US, for instance, there was a pretty big hearing in 2020 around South Africa preferences under the AGOA program, which is the African Growth and Opportunity Act, which accords special and differential trade tariffs to African countries, including South Africa. So there was a hearing. It was instigated by, the International Intellectual Property Alliance, which mainly represents kind of Hollywood content industry. is often allied to the pharmaceutical industry as well. And that organization, the IAPA, has a long history of complaints and successfully lobbying the United States Trade Representative to exert various kinds of pressure, specifically on South Africa. So you may recall as well the last time that this kind of an issue, threats by the United States against South African intellectual property policy, was front page news. And that was at the time of the AIDS crisis around the turn of the century. And the issue there was the 1994 WTO agreement, World Trade Organization agreement on trade-related aspects of intellectual property rights, included provisions actually clarifying flexibilities for countries to use various mechanisms to overcome high prices on patented goods. And so that agreement said that you could issue what's called a compulsory license. You could force a patent holder to license another company in order to allow that other company to provide cheaper drugs. Or you could, through a technical intellectual property rule called exhaustion, the idea that the intellectual property owner's right exhaust, cease to exist after the first sale of that product. And then it's up to local law to say in what market. So if you use an international exhaustion rule, that means that the local buyer in South Africa, for instance, could purchase that same good in another market where that same good was put on the market at a lower price. So in this case, back in those days, AIDS drugs, and South Africa, by some measure, had the highest percentage of AIDS patients, people that were HIV positive in the entire world. But the medicines to treat that condition were being sold at a lower price in Australia than in South Africa, which is interesting to think about. Australia is a much more wealthy country than South Africa, and it had a much lower incidence of AIDS. So there's a much more acute need in South Africa, and yet the prices to serve that need were higher than in a high-income country. And so South Africa sought to use the least aggressive of the two tools. It decided to not use the compulsory licensing tool, but it instead authorized what we call the parallel importation, gray market importation of the same branded product, not generic product, branded product from other markets where it was sold more cheaply. And that authorization within the South African Medicines Act brought the criticism and lobbying of the IIPA, the institution that I just talked about, and the pharmaceutical industry, which I believe are also members of IIPA. And they convinced the then Clinton administration to use the Mbeki-Gore Commission. Those were the two vice presidents at that time, to send messages from the United States to South Africa that its consideration of the use of this tool may lead to trade sanctions by the United States, including withdrawing special and differential trade tariff agreements, just like is being threatened now. So there's a very similar political effort that happened in those two moments. It's some of the exact same actors. It's a similar effort by South Africa to take advantage of its ability to craft its laws according to its own interests within the confines of international law. I would say in each case, almost every scholar of the really legal issues didn't see a legal issue there, but nonetheless, the threats were real. The response in that time was a social mobilization. It literally launched an organization called Health Gap, which were AIDS activists from America first, and then that organized globally to help support South African activists, the Treatment Action Campaign, etc., in the US, and to create a partnership between the Treatment Action Campaign and global AIDS activists to apply pressure in both places. And ultimately, those threats were removed. World Trade Organization passed or adopted the Doha Declaration on TRIPS and Health, which made it very clear that you could not threaten other countries for using flexibilities on access to medicines. And South Africa has never been threatened by the US on an issue involving AIDS medications since. The issue in those days was one of pricing. The prices being charged in South Africa at the time were between 10 and 12,000 US dollars a year for a cocktail of drugs that could be received at that point in India from Indian pharmaceuticals at about $300. And I don't remember what the price was in Australia, but Australia has a health regulatory system that ensures the affordable pricing of needed medications. So the problem was the intellectual property stepped in. And if you keep that monopoly, it was creating excessively high prices, especially in South Africa. And the reason South Africa often faces especially high prices is because it has the highest income inequality in the world. And so if you have a very, very small number of very, very rich people, and you have a monopoly on that market, you will make money, more money, selling a very small number of units at a very high price than you will serving the entire market at the price the whole market can afford. So South Africa will always face ridiculously high prices from the perspective of the median income earner, vis-a-vis countries with more equal distribution of income, even if, like Australia, that the median or average income is much higher. Prices in South Africa tend to be as high as prices in the US or UK, which have about 10 times as much GDP per capita than South Africa. And I know you all know this because you've been outside of South Africa, right? You've been to bookstores, you've been to record stores, you see that the prices are not very different from place to place. But when you really think about the essential items that we need, accepting that state of affairs can literally violate the rights in your own constitution. I showed the pricing of AIDS drugs, but actually prices in the book markets are very similar in South Africa. You can compare, like some of this information came out of the record that was before the parliament at various times. If you compare prices for the same exact book between India and South Africa, prices are often as much as 10 times higher in South Africa, although South Africa does not have 10 times higher the income of India. So what accounts for that pricing? And the result is kind of obvious in the intellectual property sphere, because intellectual property literally creates monopolies. If you enforce the copyright on that textbook, you enforce the patent on that medicine, and you don't have any legal rules that control the excessive pricing of those items, then as I've told you, the economic logic will enforce a very high pricing within the South Africa market compared to other markets. And so here I can kind of come out as my accent suggests, as an American legal academic. And American legal academics come out of a particular legal tradition that was created between the 1920s and the 1950s. That was a critique of the use of law to restrain policy, and specifically to make way for the reforms that created the administrative state under under FDR, for instance, and coming up into the post-World War II economy. We shifted from a much more laissez-faire system to a system with a much greater social democratic way of structuring our economy. It's the birth of the administrative state. It's the birth of the regulatory state. It's the birth of our welfare system. It's the birth of our social security system. It's the birth of our public health care system. And at that moment, in order to resist the legal conservatives who are arguing all of that is unconstitutional, because it regulates contract and it regulates property. And there are rights to contract and property within the American Constitution. So everything you're trying to do is unconstitutional. And against that, the dominant argument that wins the day and that makes us all, as American legal scholars, associate with the ideas and principles and theories of what we call legal realism, has at its core this insight from the both legal scholar and economist from Yale University at the time, Robert Hale, one of the most influential and most important legal economic theorists in the American canon, is that the distinction between the state and the market collapses within law. The market value of a property, the price, is merely a measure of the strength of the bargaining power of the person who owns the one or renders the other under the particular legal rights with which the law endows him. It is the law that determines price. If your medicines in the 1990s are priced so high that there's actually literally no way South Africa could have purchased all the drugs it needed to treat the people within the country. Because the prices I told you was over $10,000 a year, and the GDP per capita at that time was $2,500 a year. There was an AIDS incidence of over 40%. It would literally cost all of your GDP to treat just the people in the country that had HIV. But that price comes from the legal rules that South Africa at the time was enforcing. It was choosing to not use a compulsory license and choosing to not use parallel importation, in part because it was being pressured. And then eventually it chose differently. And it has since issued compulsory licenses. And now there's relatively universal treatment of people with HIV in South Africa. We changed the legal rules, which changed the price and allowed us to scale up treatment. Now, that's the political context. So what is South Africa trying to change in the South African Copyright Amendment Bill? And I'm just going to focus on the limitations and exceptions here, because that's the argument that we hear being made, that there's something in the Copyright Amendment Bill that is creating unfair exceptions to the rights of, it's often stated, authors, but it's not authors so much making the argument. It tends to be publishers and music labels. And it's important to keep casting your eye towards those two entities, because those are global monopolies, right? There's only 3 or 4 major publishing houses in the world. Almost all of the local South African publishing subsidiaries are owned by multinational publishing corporations. And the same is true for the music industry. There's only 3 or 4 big labels in the world. And all the local labels tend to be subsidiaries of the multinational labels. So it's already a monopolized sector. The distribution layer is monopolized. Artists are not monopolized. Artists often get extremely low prices when they license their work to publishers or music labels or film studios or whatever. The creative sector itself is not monopolized. It's the distribution layer that is monopolized. It's the distribution layer that sets prices. Artists don't set prices. Publishers set prices. So and artists sign away their rights to the publishers. So when we say right holders, what we generally mean is distribution entities. And that industry tends to be highly monopolized. So what is the CAB trying to do around this issue? One of the things it actually is doing is regulating on the side of artists and requiring equitable remuneration, of extending the rights for artists to control works they didn't have before, to require that contracts with those subsidiaries, with that distribution layer, expire after 25 years and need to be renewed, so prompt a new negotiation. These are all tools in Robert Hale's sense that tries to raise the bargaining power of artists vis-a-vis the distribution entities. But I'm going to talk about the exceptions. The exceptions try to do something different. Again, in Robert Hale terms, the legal rules set the bargaining position. The exceptions, by expanding exceptions, are trying to increase the bargaining power of users in the market, of users of materials to bargain for better prices for educational materials, for instance, is a key example that's raised over and over again in the record. So how do you create more bargaining power on the side of the buyers vis-a-vis those same distribution monopolies that are giving low prices to the creators, but then are flipping around and charging the buyers much higher prices? So the way you do that is you expand the limitations and exceptions within your copyright law, if that is your purpose. And I understand not everyone agrees with that purpose, but I think the legislature certainly agrees with that purpose. So one of the things that you do, and that the South Africa Copyright Amendment Bill does, is it looks around the world and it finds what I call the most open general exception. So let me define those terms. So an open exception, so this is an exception to copyright. So every copyright law gives exclusive rights to whoever owns that entity to exclude others from the copying and selling of that material, from basically competing in the market, right? And then there's always a series of exceptions which say that the copyright owner's right to exclude other people from using the good doesn't reach these other activities. So for instance, in the main international law on this topic, the Berne Convention on Copyright and Related Rights from 1886 says that every copyright law has to have an exception, at least for quotation. No copyright owner can use that exclusivity to stop someone else from quoting their work, even if they don't like the quote, even if the quote is wrong or malicious, factually incorrect. All of these are part of your free expression right, right? We can't allow a copyright owner to stop you talking about a book because he has a copyright on a book, or talking about a movie. You're allowed to quote that movie. You're allowed to criticize it however you want. It's part of the free expression interest. It would be unconstitutional, according to many courts, to have a copyright law that doesn't have that ability to use, at least for that purpose. So that's not the argument, right? The argument is not we shouldn't have exceptions. Everyone, including the people who don't like the current exceptions proposed in the CAB, agrees that copyright law must have exceptions. Copyright law, the rights, the exclusive rights, call them rights, don't trump all the other fundamental rights. And I think all of us would agree that copyright law with no exceptions would violate those fundamental rights. So then the question is, how do you construct those exceptions? can spend more time kind of banding around a lot of the terms that are used in this field, but I'll just say a lot of them are wrong. The distinction isn't between civil law and common law. The distinction can be around the terminology that I will call open and closed and general and specific. So when you craft an exception, an open exception is an exception that applies to all the different elements of the exclusive right. So the exclusive right potentially covers any kind of use. So that term fair use that you've heard battered around, the reason that term fair use is critical is actually the word use, not the word fair. Every exception actually has a fairness test. It's not always called fair. It's called something like fair. Some people call it a proportionality test. There's always some kind of protection of the rights owner to make sure that the user isn't going too far. And that's all fair means in the US context. And really that term fair occurs in many civil law countries as well. That's why I say the civil law common law doesn't really work. Like lots of countries in the civil law tradition call it fair practice instead of fair use. Well, it's the same thing, practice use. What's the difference between those terms? Nothing. But it's important that it says something like use or practice, because if you only say reproduction, then that's just one of the many exclusive rights that copyright has. But your law already had that. Your law presently says fair dealing, and a dealing is the same as a use. So people that say, oh, there's a big difference between fair dealing and fair use, that's literally not true. The terms fair dealing and fair use mean exactly the same thing. A dealing is any use. A dealing means all of the different rights protected by copyright. So at least at that moment, there's no real distinction between what South Africa has now and what it's proposing to move to. It may or may not change the term from dealing to use, and it won't matter. It will have no significance to change those terms. Both actually the present South African fair dealing exception and what it proposes to have in the future, and what I have on the screen here, which is the US clause, apply to all works by all users. That actually doesn't change, so that the exception is general in the sense of applying to all of the different works. It's not an exception just for a movie or just for a literary work or just for an educational work or whatever. It's all different works. And there's no restriction on the kind of user. You don't have to be a student or a teacher or a library or anything else. So in that respect, we call it a general open exception, and that it applies to all of the different kinds of aspects that are actually covered by copyright. Now, the change is the inclusion of the opening clause with respect to purposes. So both the US law and the South African proposal in the CAB, I just need to move this down, use the words such as. Such as. So you can have a fair use or a fair dealing for purposes such as, and then it lists some purposes, but because of the such as, the purposes are now open. You can use it for other purposes that are somehow like those purposes. It's not a closed list. So that's the open versus closed as respect to purposes. And that's the change. That's the change that's being proposed. Now, why is that important? It's important because the inclusion of that opening clause to what was already an open exception, you already have an open exception under fair dealing. So many other countries, sometimes civil law countries, only have lists of specific exceptions. They don't have a general exception that's open to all the different kinds of uses of all the different kinds of works. So you're already in the Anglo-American tradition now. By including such as, it allows the purposes to change over time. So the US fair use exception hasn't been amended since 1976. But technology has changed since 1976. Indeed, there wasn't even video cassette recorders with a record button on them in 1976, much less DVRs or cloud storage or email or all these internet search, text and data mining research. All of these things technically make copies of works in various ways, but have held to be fair under fair use if challenged, and often just exist, have never been litigated. The idea that you need litigation under fair use is also factually incorrect. What fair use gives is an argument. It allows you to say, this particular use isn't specifically mentioned in the bill, but because of the openness of fair use, I think it's fair. Look through the factors. It doesn't compete with you in any market. When I create internet search that literally copies the entire internet and puts it into a database and then spits out identifiers of where you can find those things, it's not copying the relevant material in any way that competes with the owner, so I shouldn't have to license it. That's why Google is in favor of fair use. I know that word gets mentioned a lot around fair use in South Africa. Google relies on fair use because without fair use, it can't create internet search. It's not actually about its practices on YouTube. It doesn't use much fair use on YouTube. It probably doesn't support the provisions in the Copyright Amendment Bill that would require YouTube to pay higher remuneration to artists than they do now. But it is reliant on fair use, as all major technology companies are, in order to exist in the market today. So that's the benefit.
Sorry to interrupt you, Sean, but we're running out of time. So if you could wrap up so that we could move to the chat, that would be great. Thanks.
Yep. So quickly, South Africa is not the only country considering opening its exceptions. It's not even the only country in Africa. It's not the only country with open exceptions. If you combine kind of all the different categories that we know of, there's at least 18 countries today that either already statutorily or interpretively opened their exceptions in a similar way. Usually you include some kind of such as terminology in order to do that, as South Africa is considering. Some of our recent work, and I'll show you a web page where you can find it all, looks at actually research exceptions and maps how open research exceptions on the world. Here, the green countries are the ones with open research exceptions. So it's a much larger number still. And we've also done work looking at the opening of exceptions over time, and we find that all countries, as they amend their laws, tend to adopt more open exceptions, but you can see there's a gap between developing countries and developed countries. High-income countries tend to have more open exceptions than low-income countries, which begs a question of why. So applying this, and this is fine that it's going to be very quick, because as I said, I don't think the legal issues are very serious here. So can you do it? Can you have more open exceptions under the international corpus? We start, of course, with the Constitution, not with international treaties. And both international human rights law and your own Constitution requires all state entities, including the legislature, to promote the Bill of Rights as it's amending and interpreting legislation. The specific trade arguments you can find on Denise Nicholson. I don't know if she's still creating this site, but Denise Nicholson originally created the Great Fit site that has lots of information about the copyright bill, including the background on the trade arguments. But the trade argument is basically this, that international copyright law, the Berne Convention, 1886, has a provision on exceptions that says that exceptions must be in certain special cases. And there's a decision by the World Trade Organization that says we have to give a lot of meaning to that phrase certain, that parties must have legal certainty. There's critiques of that decision. It's not clear whether it's really authoritative. Certainly the scholars don't love it. But even if you go along with it, there's nothing in that decision that says you can't have fair use and fair dealing. Indeed, and you can find papers that we've commissioned on the topic, and if you look at the latest Marrakesh Treaty on the facilitation of access for visually impaired people, you find that fair dealing and fair use laws are explicitly incorporated within the history of the three-step test and the way we've applied it in the future. So it seems pretty clear to me that adopting an open general exception, like 18 countries have, like the South Africa is proposing, complies with international law. But sure, there can be a little issue there. One could create a logical footnote to say that there's something in dispute. But why I think that this is really a non-issue is that what's not in dispute is that countries like the United States and Europe cannot unilaterally adjudicate that on their own and cannot sanction a country by denying them preferential treatment under a special and differential treatment clause just because they feel it violates that rule. They have to litigate it first, and they're not doing that. There is no litigation filed. There will be no litigation filed by the United States against South Africa for anything in the Copyright Amendment Bill because most of it's based on concepts that exist in US law. And the GSP enabling clause, which authorizes and regulates the administration of special and differential treatment, says it can't be reciprocal. You can't deny treatment of one country that you don't deny others for, or that you don't do yourself, or as an exchange of favors between two countries. So the international law really bans this type of use. And so I want to end on this point, which is to say, I don't think the most radical thing in the law is certainly the fair use clause. But if you think of that the medicine pricing slide, the book pricing slide showing the problems of high-priced textbooks within the South African market. And then you look at what's certainly the most innovative, I think, if not radical concept within the South African Act, which is to combine a competition law standard, an excessive pricing standard, with its limitation and exception, and say that if the textbooks are priced too high, then you're going to have a broader fair use type standard to use even a whole textbook within an educational market. And it can't be for a commercial use, but we're not going to deny our children textbooks because the monopolies are pricing them too high. I think that's an interesting standard and is probably the most innovative one. And I think it complies with the international rubric as well. But it's interesting to see so much of the focus being on a fair use clause, which as an American looks like really standard fare that we've had for over 50 years, as opposed to some of the more interesting parts of the legislation. So with that, I'll stop. Thank you very much. I'm super happy to ask questions. I see that there's a few in the chat, and maybe I'll have Sanya maybe pick up where we should go from here.
Thanks so much, Sean. That was really fascinating. I was really fascinated by the slides that had graphs and the quantitative analysis, because we don't see that often. So it's just really interesting to see that data bear out your conclusions. There are a few things that came up in the chat, and I'm going to summarize them. The first one was a concern that came up, which was that the Berne Convention is also about the right of authors to earn a living from their content and not just about the global mandatory fair use quoting provision. So that's the first one. And the second one is sort of similar. So I'm going to club that. Another intervention in the chat said that artists are the ones who don't have bargaining power. So similar sort of like authors' rights issues. It would be really great if you could address that, the first thing. And the second is, I'm reading directly from the chat. Fair use with respect is a blanket term as compared to fair dealing in South Africa. Hence, the industry is fighting the Copyright Amendment Bill in its current form. So that's the that's the quote from the chat directly. The concern seems to be about the blanket term of fair use as compared to fair dealing. So if you could address that, that would be fantastic. I also see in the chat another comment that the Copyright Amendment Bill, in fact, increases the bargaining power of authors, musicians, artists, and performers. So these are all concerns that relate really generally to artist rights. I'm going to club with that a short question from my side about authors and users. You're talking quite a lot about that. So I guess my question is, how helpful is it really to draw bright lines between authors and users, especially because I'm speaking from my perspective. I'm an academic, so when I write, I use other academics' writings through the WITS library databases to author my article. So how do exceptions and limitations help me as an author? I also see another comment in the chat that relates to South African book pricing in the market. And I'm going to read it out for you. Unfortunately, the view that South Africa book pricing market is high is erroneously based on a serious policy that the South African book market is highly and fully in the hands of overseas publishers. Full stop. This makes the further argument that the CAB supports the creation of affordable book prices rather preposterous. Kindly check the facts. So if you've got a response to that, that would also be helpful. The question, or rather the concern, seems to be about the local publishers versus international publishers and book pricing in South Africa more generally. I'll leave that with you for now. I see that we've got about 10 minutes for you to respond to all of that. If everyone's happy to stay an additional 5, then please go ahead and continue. Finally, before I mute myself, there's another comment that talks about how American law has low relevance to this discussion. So if you could perhaps explain the extent to which you think American law is relevant, that would also be helpful. Thanks very much.
Sure, and so I'm going to kind of cluster those together and do the best I can to give kind of some roots through the analysis that's common. So I mean, first with there's a comment that around authors' rights to remuneration being an interest of the Berne Convention, and then also the real problems around artist bargaining power. I mean, there's kind of broad and more specific answers. So first of all, it's really interesting that there's nothing on artist remuneration in the Berne Convention itself, actually. If you look at, I spent a lot of time in the World Intellectual Property Organization. If you look at their current agenda, the current agenda includes, on the one side, to try to have new agreements and understandings on limitations and exceptions, so exactly what I've been talking about mostly today. But on the other side, there's actually another item that's being sponsored mostly by the Latin American countries, but also by the African group, to spend time trying to figure out exactly that issue, which is what are the rights of authors to remuneration. Now, as one of the commenters noted, that it's really, or I can't remember exactly how they phrased it, but it's authors who need to increase their bargaining power. And that's true, that it's both authors and buyers that need to increase bargaining power if your goal is to raise remuneration of artists, the actual creators of works. So if that's one of your goals, then you need to increase their bargaining power. If your interest is to decrease prices or expand the uses of users, then you need to increase their bargaining power. You can do one and not the other. There certainly may be authors who believe that we should focus on just the remuneration and ownership rights of authors to increase their bargaining power and not try to address consumers' prices. And that's fine. That's a logical position. It doesn't seem to be the position that the South African CAB is taking. The South African CAB appears to me to be both trying to raise prices to authors vis-a-vis distributors, vis-a-vis labels and publishers, and increase accesses to use by users, again, vis-a-vis publishers. And So there have been interesting, and there are interesting kind of global formations of interests. And in South Africa, I believe it's called the Recreate, network, that tries to bring in, on the one side, creators, so actors and musicians and things like that, and then also users, with the idea that the collective problem is the monopolization of the distribution layer, not necessarily authors having fewer rights or users. So the idea, you can increase the rights of both the users and the authors, and that the common problem you're trying to address is the distribution layer. So that, I think, is what the CAB embraces, is that both the bargaining power of the authors and users should be increased. Again, you can do one or both of those things, but it's interesting to see both of them. On the difference between fair use and fair dealing, I mean, I'll just reassert that those terms, by definition, the use of those terms within law around the world means exactly the same thing. And so the difference between the two, and where there is a debate about whether this is good or bad, is not the terms fair use or fair dealing. It's the terms such as. That's the debate. That's the change. The change from the current South African law to the proposed copyright amendment bill in section 12A, the key change is the inclusion of the words such as. So it makes the list of purposes open, means you can apply that exception to other fair uses for other purposes that are not specifically mentioned in the bill. And the proposed benefit of that, again, this is a policy debate. The CAB adopts its own position. Parliament seems to be adopting its own position. But the reason why those who think open exceptions are good, the reason why they think they're good, is to future-proof the exceptions, to have exceptions that are as broad as the exclusivities. So ultimately, everything turns on a fairness balance. If the use that you're trying to use is fair, including especially whether it competes in the market, is it a commercial use? Does it take away market power of the rights owner, which is normally the publisher? Then it can't be fair and it can't be lawful. But the fairness analysis is no longer just a checklist of what specific exceptions are listed. It can be a fair use even if it's not listed as a specific purpose for that use. In practice, I don't think it honestly does very much. I think that the debate here is a bit misguided. Most of the reasons that people use works in South Africa now are either covered by the current fair dealing, or there's no litigation over them, etc. It gives a bit of a legislative vehicle to saying that these various modern uses that aren't mentioned anywhere in the Copyright Act now are also permitted. It also gives the ability of those publishers who disagree to sue. And the litigation will be over whether that use is fair or not, which is what it should be. The definition of fairness is whether there's an unfair diminution of the value of the right holder. So that's what it does, and you can agree or disagree, but that's what it does. But I think the level of attention probably that one little issue gets in South Africa is a bit overinflated, but it reflects definitely a global politics, which is this direction, which I kind of mapped out as the direction towards fair use type rights defined as more general, more open exceptions, is that direction, which is the dominant direction in wealthy countries. Is it a good direction for poorer countries as well? And that's a policy choice. The rich countries have decided that it's good for them, So if you look at the latest European Copyright in the Digital Single Market Directive, it's all moving in the direction towards more open exceptions. It's requiring that of all European countries. So why are their interests different than yours? And maybe they are, but that's the policy question that's being debated. The question around book pricing is just an empirical point. I was referencing material from the legislative record that suggested that one of the policy objectives of the bill is to combat prices that were considered excessive. And there's other examples as well. If the prices aren't excessive, then the copyright bill does not allow that expansion of fair use that only applies in terms of excessive pricing. But it is interesting that the bill introduces an excessive pricing clause within the Copyright Act. That's novel and new, and I think it's worth debate. But if there's no excessive pricing in South Africa, then that clause will never actually be used. And I think that's what I have to say. I see we're to the end of our hour, but I don't know if there's something else that someone would like me to address.
Thank you very much for responding to those questions, Sean. I guess there's one final, I mean, there's a sort of ongoing conversation in the chat, which you could perhaps have a look. I think you addressed quite a lot of that.
I see that there's one person that is interested in having extended dialogue. I don't think we should take all the questions from one person, but I think it's fair to
not at all. I think you have addressed most of the concerns, because the concerns related really to creators' rights and how the CAB would or wouldn't ensure that creators' rights are protected. You have addressed that to some extent. And I suppose that also speaks to the question I had about me being a user and an author at the same time.
Oh, I forgot that one, yes.
No, not at all. So if you have anything more to say on that, then please go ahead. But otherwise, and if you have any sort of concluding comments that you'd like to make, then the floor is yours. Sean, is there anything you want to say in conclusion?
Well, I'm happy to comment on your question as well, which I think is a derivative of the other questions. I think the big piece here is kind of in copyright markets is to analyze who you are in relation to whom. And I think there's a tendency on the forces that oppose all kind of user rights and also oppose the rights of remuneration, so that would be that kind of monopolized distribution layer. Those are the ones who don't want increased rights of authors and also don't want increased rights of users. So those interests are economically uniform, but they're not the authors or the users. And so you're correct that once you move down and you say, so who are the people whose power is constructed by that layer? It's both the authors and the users, and you're correct that they're often one and the same. So if you're a documentary filmmaker, you're a creator, you're a producer, you're a filmmaker, but how do you make that film? Well, one is that you have to tell the story by using the visual and audiovisual images of others. So there's an open question. Do you have to license those uses? So if you're quoting from someone else's movie and you want to quote it within your movie, if you want to tell a story of the South African struggle against apartheid and you want to show images from movies that depicted that struggle and show how they changed over time, then how do you do that? What does copyright say about that? Well, the copyright law could be one of two things. It could say that's fair use because it's in your freedom of expression interest and you can use that even without licensing. Or it could say that's part of the exclusive right and you have to license that work. Now, what's the interest of that creator? Is the interest of that creator to have to license that or to not have to license that? And then what if you're a South African creator? Movie licensing markets are the same as medicine markets. They're going to charge you the same price they charge a Hollywood filmmaker. even though you have 1/10 of the budget or 100th of the budget, you're going to face a global price. So the rule that South Africa has may need to be different than the rule that the more wealthy country has. Otherwise, you're going to exclude that creator from using. Now, I'll tell you the answer in the US to that question. The answer in US is largely the uses of those clips are considered fair use for documentary filmmakers to express the informative points of their movie. Should that be the same rule in South Africa? That's one of the open questions under the Copyright Amendment Bill. Thank you, Sanya. This has been really great. It's been really fun.
Wonderful. Thank you so much, Sean. Thanks very much to the attendees as well as to people who engaged in the chat. And yeah, hopefully see more of, I look forward to seeing more of you at the next webinar as well. We will communicate that. Many thanks also to the Mandela Institute and PIGIP's administrators, Magda and Dagniat, for your help. And see you all again in a few weeks. Thanks, Sean. Thanks, everyone. Bye.
Yes. Thank you very much.